I got it.
Mr. Chairman, are we going to do the tag bids? How are we trying to do those tag bids? Because you know I asked you about the other day, last Monday.
Nobody got anything out of rules yet, so we're gonna have to try to find something like we did last year. So,
Okay.
and that's the plan.
Okay. I just wanted to know, like, I know if I need to go talk to chairman, the rules chairman or not. Just like,
No, we're gonna try to combine them all and add them on something in the Senate, and then come back through for an agree. Something we passed. Well, good morning. It is 8:02, so we're 2 minutes late, but we're gonna go ahead and get started. Vance, you opening prayer for us. 25. How about 26?
Thank you, Mr. Chairman. If you'll pray with me. God, what a beautiful day you've given us. We ask that you lead us. Your hand's always extended, so all we need to do is hold on and follow your will. You've got a plan for us. And we ask this morning that you be with people that are hurting physically, their heart's hurting. We ask that you heal them and comfort them. And lead, guide, and direct us, Lord. In Jesus' name, amen.
Thank you. We're going to start with House Bill 935 this morning. Representative Ken Vance. Did he step out? You want to come to the table or podium, wherever you want to. And we've seen this bill before, and it was in a different number, and it was a Senate bill, I think, when it was before us last time. But
Correct.
And they kicked it back, and we put it on a House bill. So if you tell us what we're doing.
Okay, so Mr. Chairman, this is the Back the Blue Act. It's to help hire and retain experienced law enforcement officers. How this will work is there will be what will be determined as a Back the Blue fund in the Department of Revenue. When a person goes to buy their tag, they can voluntarily contribute to this fund. These funds will be sent from the county to the Department of Revenue, who will collect them for an entire year. But there will be monthly reporting mechanisms that will have to be done by the Department of Revenue on a monthly or quarterly basis to show how much money's being that comes to them. By January 1 of 2026, those funds that have been collected by the Department of Revenue will be given to the Georgia Sheriff's Association. The Georgia Sheriff's Association will distribute them to each county in the state of Georgia equally. No county gets more than another. Then the sheriff of that county, who is not eligible to receive any of those funds, will distribute those in a fair and equitable manner to his or her deputies that are certified, and that will happen on a one-time basis. So as it moves forward, this bill does have a sunset of 2029, and on July 1 of 2029, and we'll review it again at that portion. There will be reports given back to us during the year to see how healthy the fund is and how it's working. But for that 3-year period, that is the Back the Blue law and Back the Blue fund as I'm presenting it today. And I'll be glad to entertain any questions.
And like I said, we did pass this bill last week. It got kicked back from rules to us since it's dealing with generating funds it needs to generate in the House. So that's why it came back. So anyway, we do have one question, number 18, Representative McLean.
Thank you, Mr. Chairman, and I do like the bill. I just always have concerns when we use the word equally, and we're talking about 1 million people in Gwinnett County and 10 people in down some other county, and I'm just trying to figure out how that really is equal because I mean I could see equal if each sheriff got each deputy got the same amount of funds, other than the department getting the same amount of funds. But I understand what you're saying. But I just want to, I just have concerns.
Well, sometimes, Representative McLean, I think the haves have to help the less than haves some. And that's what this does. This, yes, will there be more money collected in Cobb County than there is in Sly County? Absolutely. But when it comes together, it's all distributed out equally. Sly County is gonna get the same amount, and it's gonna go a pretty good bit as Cobb County, which it may not go as far because of the numbers. But because Cobb County's contribution to it, or whatever big county, then it makes it better for everyone. It is fair and equitable across the state, even though the counties with the high populations and the high tag counts are going to contribute more to that fund than, say, a Sly County or a Bacon County. So I understand it, but this is it's really fair and equitable across the board. But if you look at it from Cobb counties to the Bacon counties, it says, you know, Bacon County's gonna come out better and they're not gonna contribute as much as Cobb County. Well, they can't, because they don't have that number of people. But it is fair and equitable, at the end of the day.
Thank you.
Bless you. Yeah, and like I said, we did pass this bill week before last and kicked it back. I think number 27 has a question.
I was just going to say, I like the measure, and then just as a reminder, it's voluntary. So
Yes,
people
sir.
that are going
It's
to
voluntary.
contribute to this, they'll understand it's going to one place, which is to ultimately help all public safety. Appreciate the bill. I'll make a motion to pass at the appropriate time.
Now would be the time.
I'll make a motion to pass.
We got a motion and a second. Any further discussion? All in favor say aye. All opposed, like sign.
Thank you, Committee,
Bill
I
passes.
appreciate it.
On the rules. All right, 939, Representative Reeves.
Chairman Corbin and members of the committee, I present to you a modified and more focused version of House Bill 939, the Breaking the Cycle DUI bill. Before I start, though, let me say happy birthday to Representative Smith. Happy birthday. I'm going to go see Representative Sharper to ask him to get warmed up today, because got a birthday in the House.
39?
All right. This bill, it reminds me of when they asked Michelangelo, how did you sculpt that statue David? He said, I just took a block of marble and I knocked off all the stuff that wasn't David. And so I appreciate this committee getting this bill in good shape. I have listened to all the feedback in the committee, both in the meeting and offline, and here's the current scope of the bill. If you want to keep the normal process that we have right now to get your driver's license back if you have a DUI, under most circumstances you can follow that route if you think you're innocent. However, if you blow a .08, or if you have a blood test that says .08, if you apply to get your temporary license, in order to get your temporary license, at that point you would need to take the state-approved DUI course. That would achieve this bill's mission of having DUI offenders take a class before they get back on the road. That would be close in time to when they had their encounter with the law enforcement, as you heard from Ina Mitchell, and as the chairman has the voluminous studies in his office. That is the most effective way to cut down on repeat DUIs, is have some good training right after they had their encounter with law enforcement. Mothers Against Drunk Drivers are now looking at the bill, and they've informed us that 1/3 or more of DUI arrests are repeat offenses, and some of the worst DUI wrecks are ones that are repeat offenses. This bill is the best thing we've got in 2024 to cut down on repeat DUIs. You have asked for something that has due process. This is the best thing we found to do due process, to have that .08 standard either through a breathalyzer or through a blood test, and then that way that takes away the subjective roadside sobriety tests and things like that that committee members had some concerns about. So thank you for your input, which narrowed and focused the scope of the bill, and respectfully request for you to give this a try this year to see if this works in reducing recidivism on DUIs. It's worked in the military, it's worked in other states, and this will cut down on repeat DUIs in Georgia if we give it a try.
Okay, we do have a couple questions. Representative Kennard.
Thank you, Mr. Chair, and Representative Reeves. I appreciate the edits to this bill, and now it's at a place where I can support it. And I think it's a good measure. Thank you.
Appreciate it. And thank you for your input on that. I took that seriously. You can have the Constitution and due process and cut down on repeat DUIs. The military's done it, other states, we can too in Georgia.
Number 26, Chairman Smith.
Thank you, Mr. Chairman. So, Representative, currently, how does somebody get a temporary license? As before this bill, how do they do it now?
They petition the Department of DDS, and there's an administrative process for them to pursue getting their license back. And there's no requirement for them to take a class. That's merely in the DUI court system. What this bill says is if you go ahead and take that class, whether you have a .08 or otherwise, you can still use it in your criminal case to show the judge you've taken the class. If you get sentenced to it at the end of the day, you've already taken it close in time to your encounter with law enforcement. But this preserves that administrative process for those folks who want to do it, and it limits the scope of this bill to folks who've had a pretty flagrant DUI of .08 or higher.
All right. We don't have anybody signed up to speak to the bill. Number 24, Chairman Powell.
And I appreciate the bill, even though I think this ought to be called the Martin Moynihan Retirement Bill. But you know, we did do this once upon a time, and you know, the only suggestion I would say is on line 28, where you've got DUI, alcohol, drug use risk reduction. That should say state certified. We've got courts in this state that we've had an issue with for years, that a lot of the courts, they have their own programs. And quite frankly, that seems to be a retirement program for their clerks and stuff like that. So they have some kind of little program that they use. This needs to spell out state approved or state certified, whichever would be the appropriate language for that, to be sure that these are programs that are approved by DDS.
And Mr. Chairman, it's my understanding that that's a friendly amendment, and I think that's totally appropriate. The schools I have in Gwinnett County, it's my understanding that's what they use. And I had a bad DUI wreck in my area at 120 in Peachtree Industrial a couple of years ago. The police officer still hadn't come home. This is somebody at 2 or 3 o'clock in the morning. Police officer was not even going after him. He hit the police officer, and he's been in nursing facilities for years. So state certified programs will have results.
Or certified by the Department of Driver Services, or if somebody's from DDS, it may be here today.
I don't see
friendly
DDS
amendment
here. If you'd like to offer that amendment.
At the proper time, I will.
All right. Seeing no further questions, what's the will of the committee? We got a do pass. We have a second? We've got a second. All right. Now, do we have a amendment?
I
And
think the proper word would be completion of a state DDS or Division of Driver Services approved or certified program, whichever one would be appropriate.
Jenna, did you hear that?
It's a defined term. We added it as a defined term to the title, so it says it's a program certified by the Department of Driver Services in accordance with the subsection, so putting it in there would be redundant.
It may be redundant. It may be.
Try it again.
It may be redundant, but I think it would send a clear message to a lot of these courts that are doing their own programs. A lot of judges just kind of wave over the written law.
Jenna, can you read that back? Okay. We have a motion for an amendment. Do we have a second? We have a second on the amendment. Now we will vote on the amendment. All in favor say aye. All opposed, like sign. Now we vote on the bill as amended. All in favor say aye. All opposed, like sign. You have the bill.
Thank you so much.
I guess the fourth time's the charm, right?
That's right. That's right. Thank you.
Okay, I see Chairman Jay Collins hiding behind the column over there. I'm going to ask him if he will come forward and tell us about House Bill 1239.
Thank you, Mr. Chairman and members of the committee. It's always a pleasure to be here with you today. I've got House Bill 1239 for the consideration of this committee, and I want to give you a little backstory behind this piece of legislation. So I think it was last year this committee passed out some legislation that allowed these ATVs to be on county roads throughout the state, because you had so many of these manufacturers that were making these vehicles that were more than just a rail dune buggy type ATV. They have cabs, and they have a lot of accessories that on-road vehicles would have. And so that legislation passed, and during the interim I was approached by numerous constituents and people throughout the state because that legislation prohibited, or did not enable, I should say, these little small Japanese key cars. That's a derivative from the Kadushiwa Japanese term, which means small vehicle, from what I understand. And I think you're probably familiar with these small vehicles. They've been imported over the years. And I did a little research, and various county tag offices were issuing tags to these small Japanese mini vehicles for a while. And then sometime over the last year, there was a ruling by Department of Revenue that would prohibit those vehicles from having a tag and being on the road. So what I put forth today is just some legislation that would...
Mr. Chairman, read that LC number. I apologize.
I'm sorry, I'm working off of LC 394256S.
Well, that's not the one we have.
Can I have a copy of that? I think there was there was a change to the bill as far as the dates for activation, or for it to be put into place. So I believe that was the change. But nevertheless, in this legislation, you will be enabling these key cars, Japanese miniature trucks and vehicles, to be on county and city streets only. That was one of the things that I think DOR had an issue with. Is, these little small vehicles would be great for someone like my friend Chairman Powell there, who doesn't necessarily want to have a golf cart, but he wants to have something that he can go out in his backyard and pick up limbs and leaves and debris, and then take his 5-gallon gas tank and run up to the store, pick up 5 gallons of gas, and drive his little truck back down in the back of his yard and do some work. So this is the genesis behind this bill. It's just enabling these vehicles to be on city and county streets, and I'll be glad to walk through the bill with you. One of the main caveats here is, if you'll look on.
Mr. Would it be possible to get somebody to run some copies off for us? Can we pause?
Sure, absolutely.
That way we follow along on the same bill. It's kind of hard to.
Do y'all not all have a copy of that?
No, but
Do you all have a copy of that?
we've got LC 394166,
Yes.
and that's okay.
I've got Chairman Prince's there.
Okay.
No, this is it right here. No, that's
Okay.
you have the most.
Okay,
you have the most recent.
so you're working off the copy we have. That's
Yes, I'm
that's
working off the
one
copy.
we'll, okay.
I'm working off the copy. that you
Making
have.
sure we're on the same one. Okay.
Yes.
Thank you. Yes.
Yes. Yes, the only
Number
change.
24.
I'm sorry.
Moment.
The only, let me say this, the only change to the bill, was in we added on section 9. This act shall become effective on October 1st, 2024. That's the only change to the bill.
Oh, I was about to say.
Here it is right here. If you need me to suspend and you go to another bill and come back. that'd be fine.
If you would, that way we can work off your substitute with the, or that would be great. I-
That's what Jenna recommended, so
Do
it's
I-
just an effective date change is the only thing, so if we wanted to do that.
Okay, all right. If the committee is agreeable, we go on with the bill and we'll just amend it.
I mean, and lay council, if you don't mind, that was the only change in that bill, wasn't it? Was it, okay. So if you'll start on line 15, you see, the miniature on-road vehicle is mentioned, there for use in this country. And it talks about, the description there operates between 25 and 65 miles an hour, the legal description, if you will, designed to travel on 4 or more wheels. These are not 3-wheelers. These are not 6-wheelers. These are, there's not 3-wheelers or 2-wheelers. They're 4-wheel vehicles. And it talks about the gross weight. Also talks about these vehicles that were manufactured before January 1st, 2000, or it talks about the age of them. Most of these are imported after they're 25 years or older. And then, let's see, if you'll skip down to lines 96 through 106, there's the language just codified there as far as the description. And then the part of the bill that I added after we got to looking through here, it just talks about the prohibition of these on any resolution. Excuse me. It talks about that local jurisdictions can prohibit these through a local ordinance. So if you live in a community where your city or county does not want these on their local streets, they can do that. And Mr. Chairman, that's pretty much just the genesis of the bill and the bill itself. We're just limiting these as imported vehicles that are 25 years old or older. And then on the other portion of the bill, that in section 9, we're waiting till October for this to go into effect.
October 2024.
Yes, that's right.
All right, we do have a couple questions. Representative McLean.
Thank you, Mr. Chair. I guess, when you told me I could have local legislation to say not to have and have, so I live in one county and I drive my vehicle into another county, so the police I get a ticket. I mean, I'm just trying to figure out how this is going to work. If my local says that we don't allow this vehicle in our county, and you drive that vehicle in this miniature vehicle and off into that county.
Well, it's similar in my mind to we allow golf carts in certain cities and counties.
They don't have tags. I'm sorry, Mr. Chairman.
They don't, but they're still allowed to be on county and city roads in certain areas. And, those jurisdictions, they have their jurisdiction for a reason. So I would just argue to you that, these are not designed to go from one community, I would say, to another. It's just like with a golf cart. The golf cart's not designed to go from one city to another. It's more of a localized transportation. And you can't ride these on or drive these on city or state and interstate highways. And that's one of the reasons that DOR pulled back those tags being issued. I was talking to a member of DOR, and he was saying he was driving down the interstate, and here's one of those little key cars passing him running 75 miles an hour. And that's not what they're designed for. So, you've got a lot of people that already purchased these. They've got them in the state. they had tags for them, they were using them in a proper manner, and then all of a sudden the state pulls the curtain and on them, and they're prohibited from being used. So all we're doing is just trying to make these permissible by law. And if you live in a community that doesn't want to allow these, they simply pass an ordinance and prohibit that.
Follow, Mr. Chair. So are you telling me that these are going to be treated like golf carts?
I would say, maybe a golf cart on steroid. They'll be treated just like an ATV.
The bill we passed last year.
We passed last year.
Side by sides.
Yeah, these side-by-sides are allowed on highways now, or on county roads. And so this is just basically allowing these types of vehicles. I mean, these types of vehicles are equipped with headlights, tail lights. Some of them even have airbags, air conditioning, roll-up windows, four-wheel drive. I mean, these are miniature vehicles, and they're designed to be on roads overseas. And I think they're a really good concept. I mean, if you look at the building authority, they have some small vehicles that they utilize around here, and I think it would be very valuable tool for a lot of constituents in a lot of different districts. But you do present a good question, but I would just say to you, if you're going to operate a motor vehicle, you need to know the rules of the road, so to speak, and a little adulting is required if you're an adult.
Thank you, Mr. Chairman.
Number 24, Chairman Powell.
My friend,
Yes, sir.
I think what you're talking about is these little utility type
Yes.
wagons
That's right.
that they're not necessarily used on golf courses, but some of them they are.
No, that's right.
The
Yeah.
kind, but I got a question. If you look on 103, and this might need to be directed to Jenna, I notice there's nothing in here about headlights, brake lights, and things like that. But I'm just wondering if that starting at 103 to comply with the U.S. safety, will that include that?
It's at 112,
Yes.
just get added to the list.
Ba-
Like three-
Part,
So that would
part 5.
So we added that to be required for these vehicles.
Part 5 of
On
the
line
bill.
112.
Says multi off-road vehicles and many on-road vehicles shall be equipped with headlights, brake lights, tail lights, rear view mirror, and safety belts.
That answers my question. I was just curious, just in case me and Chairman Tarvin are in one of these things, we want to be sure there's tail lights on that thing, because they'd never get he and I out of that thing.
If you and Chairman Tarvin get in one of those, please let me know.
All right, seeing no further questions,
And again, Mr. Chairman, if it be the will of the committee not to pass this legislation, I mean, I trust the opinion of this committee. And, my posture when my constituent came to me was, he said, hey, you're allowing ATVs to be on these streets. And he said, my vehicle and the majority of all these vehicles, I mean, they have taillights, tail lights, air conditioning, they're a mini vehicle, and they're probably more equipped to be on the road than an ATV, and that's all I would just say to the committee.
number 27.
Chairman, I appreciate you bringing this measure. In fact, I think DOR would tell you that I've reached out to them about this very topic. So I have constituents that are also, again, have reached out to me about this very thing. These are useful small vehicles that are not meant to be going long distances, but are very useful for the short term. So, Mr. Chairman, I like the bill, and I'll make a motion to pass when the proper time.
And to keep from having to do an amendment, you now have the correct LC, the sub, in your hand, and the only change, like I say on Section 9, is the effective date. So we will be voting on LC 394256S. That's what
Is
everybody
there
has.
anybody from DOR here? I don't know. Yeah. Mr. Chairman, if you don't mind.
Yes,
Austin,
absolutely.
Austin, you have anything you want to add to this? Austin and DOR have been very helpful in working through this. They came to me with some concerns, and we worked through the process and tried to make it to
We
where.
have a little technical difficulty here with our new screen. Just talk loud.
Thank you, Chairman Corbett. We don't have any administrative issues with the bill. As Chairman Collins mentioned, the historic posture of the department has been not to allow the registration of these vehicles because they do not meet federal motor vehicle safety standards. The way that House Bill 121 was written regarding MPOHVs was to carve MPOHVs out from those federal standards, and so this bill does the same things. Therefore, since that carve out is there, we don't have any administrative issues with the bill.
Do we have any questions for Austin this morning?
And one more thing I'd like to ask, is that not true that there were tag offices that were issuing tags to some of these key vehicles?
Yes, sir. There was some misunderstanding.
Okay.
All right. What would be the will of the committee? We have a motion and a second. Any further discussion? All in favor say aye. All opposed, like sign. All right. Chairman Powell, you mind coming and run this meeting? I got a couple bills if you would run the committee for me.
Thank you, Mr. Chairman.
Yes, sir. You.
All right. All right, Mr. Chairman, you have the floor, and you're going to bring forth HB 1234.
Thank you, Mr. Chairman. You know, for the last, well, about as long as I've been on motor vehicles, LC 394289S is what the copy we should have in front of you. Yeah, we've been trying to do something, get our arms around the issue with temporary tags, abuses, dealer tags. I've worked all sessions, some during off session last year. We got real close with some language that I thought we had everybody at a good place, and we didn't quite make it to the finish line. So what you have in front of you is kind of a we're kind of nibbling around the edge a little bit. But the second bill I'm going to present to do a study committee, hopefully we can get across the finish line with that next year. But this bill, and I might have to get somebody with DOR to come up and kind of explain some of this to me. But it's basically a lot of cleanup language, like in section 1, lines 22. I mean, that's pretty much already current code. We just restating it here and striking it in another section. I mean, that's pretty much already existing. You're requiring somebody, once they come into the state, to you got 30 days to register your vehicle, and the fines and all that. But that's, like I said, that's just restating it here in section 1. Section 1 also on line 75, the valid county detail. That's already existing code, and based on 81. If anybody's convicted of that violation for not having the county decal, it said what the fine will be. But then if they can prove that they evidence that they paid for it but didn't receive the sticker, that's waived. So that's not a hard thing. And if there's no room to put it, you don't have to put that county decal. Section 2, we get into more of the meat of the bill at line 114, where the department may provide by rule and regulations the sale of these TOPs, temporary operating permits, and that's the meat of the bill. The department will be able to promulgate rules. They'll be able to suspend if they do an investigation and find somebody has violated selling these TOPs illegally instead of actually putting them on cars that was actually sold. They have the authority now to suspend their ability to issue TOPs for a set time, but there's also a review process before that happens. That if the dealer, for use our new car, will have to come and show proof that what they did was legal. But if they can't provide that proof, then there's further suspensions up to longer times. That's what's the meat of the bill on the TOPs. Pretty much in section 2 is what we're doing there. Then section 3, 4, and more just clean up language. section 5, just lines 273, where we get to the records that they need to maintain. And then that new language in 276 talks about the information contained in records maintained by the dealer, and it talks about the what they need to do, and if they violate this, what the penalty would be. And then the last section has to do with anybody remembers from the presentation that we had one last year from DOR right at the end of session and very first meeting this year. But Montana plates, you have these pretty affluent individual coming here, and they'll form these shell corporations, and it'll be registered in Montana. They don't have a business in Montana, but it's a shell corporation, and they'll go out and buy Lamborghinis, Ferraris, Bentleys, these $250,000 cars to get around playing TAVT. So what this bill does, it sets up a process to go after the bad actors in Section 6, and that's what we're doing in Section 6 of the bill. So I think we have somebody here with the new car dealers and used car dealers, and talk with both of them, and we don't have significant heartburn with what we're doing here from either side. Nobody signed up to speak to the measure far as from those two. I know we have somebody in the audience has signed up to speak, but that's what we're doing with the bill, Mr. Speaker. Mr. Chairman. But anyway, that's what we're doing, and I'll stand for any questions. And I might have to call for some help. So.
All right, number 9, Mr. Monahan.
Thank you, Mr. Chairman. Chairman, thank you for the bill. I did have a couple questions. I think I didn't see it in there, so I think you've already taken care of it. But in Paulding, I know we sell the in-guide we trust stickers for the tags. I didn't see that you were touching that.
No, we're not touching that. And your county decal, if there's room for it, you can put it, but there's not.
Okay. Thank you, Mr. Chairman.
That's not an issue, yes.
And one more, if I want to run through the, so I've got a bit of laryngitis this morning. Want to run through this line 290. Honestly, this may be for the Department of Insurance. 290 through 293. What I'm thinking is, and I'm trying to imagine a passive entity. I know that, I have several different companies. Some of those I receive passive income. Some of those I receive active income as an active partner. And I think that's probably the designation that they were going for here as a tax standard. Is that correct? Okay. Do we recognize passive and active income in the state of Georgia as it pertains to income tax? You do. So that's something that we do on the state side. I'm not a CPA by any stretch of the imagination. I'm trying to imagine a scenario, and I think I can, where a person has an entity that's formed under the laws of another state, who has control over the entity, but runs passively. I think. Can y'all tell me how you derive that? And not something that I do. I don't know that if we can. Is there? I guess a lot of things come to mind. Interstate commerce and how are we regulating in other states? Ability, and I know they're supposed to register vehicles, right?
Right.
As soon as they move here, but.
So my name is Matt Christie. I'm an attorney at the Department of Revenue. This provision only picks up, not only does the company have to have only passive income and be based in another state, it can't be based in Georgia. It can't have any active business, and it has to have a vehicle that's in Georgia. So if you have a Montana business and it doesn't have a vehicle in Georgia, it's irrelevant to you. It only picks up your vehicle if you have it in Georgia for 60 days or more. You're driving it around Georgia when you should get a plate on it within 30 days. It doesn't affect any of those passive entities. It just affects their car, and really just affects if they're going to pay a penalty.
Okay, so if do they have to meet the standard of a nexus in another state of $100,000 more transactions, or what's the limit of having? Could somebody say, oh, I do business in Montana, I go fly fishing every year, and I take clients.
Right, but if there's no vehicle in that entity is not affected at all. And if it's a Montana vehicle that's driving around Montana, it doesn't affect that entity or that vehicle at all.
So let's say I have put. I'm just saying, because I'm trying to think through that. I'm not sure I understand. So if as part of one of my companies, I set up a, LLC shell company, and I take my folks out to Montana to treat them as part of what we do for our clients. But as part of that, I register my Lamborghini in Montana, but I drive it in Georgia. I'm actively doing business in Montana by taking folks out fly fishing, yet I'm still getting the benefit of this tag.
So
does that make sense?
So if you have employees in Montana, fly fishing guides, then you're an active business, so this doesn't affect you.
So we can. I'm just saying there's a loophole here, right? I don't think. If we may want to make that a little stronger as we move forward, because I think
and that's the next bill I'm talking about. I think we can
Okay.
address that further with the study committee.
All right.
So,
Thank you, Mr. Chairman.
All right. Let's see, number 18.
Thank you, Mr. Chair. I guess what I look at on line 79, it was a $25 fine, then it was $100 for the second and the subsequent offense. But then you went to line 82 and you just did $25 fine. So it would just be a $25 fine every time they do it?
and that's talking about the county decal in that
Yes.
section right there. Yes.
82, yes, line 82. Yes, I didn't know but at line 79, you was 25 for the first and $100, they did it again. So I didn't know if is it going to be $25 every time? The second offense will be $25 too.
And that's the way I read that, yes.
And that's the way that you wanted it to read?
Yes, I mean, to me, that's not a big issue because all of them don't have county decals anyway.
Right.
I mean, something like you said, in God We Trust. Some of them have, whatever organization down there. So that's, to me, it's not a big issue, not to get hung up on.
Thank you. Thank you, Mr. Chairman.
I don't see any other questions from the committee. Yes, I think this would be the proper time. We have a motion. We have a second. We have any other discussion, amendments, or anything otherwise? If not, all in favor say aye. Aye. Opposed? The ayes have it. All right, we have, next up, House Bill 565, House Resolution 565.
And thank you again, Mr. Chairman. We're working off of LC 393930. And we passed this bill last year. We never got it out of rules for this study committee, and it's for the stated reasons we just talked about. And like I say, everybody in here has seen the presentations from DOR, the abuses that are going on other states. There's videos out there that shows you how to become a used car dealer in Georgia, and you don't even have to have a lot. They're showing them how to get around the system. New York has a huge problem with tops, coming from Georgia. And I think I seen Miss Leslie come in earlier. But anyway, Commissioner Moore, when he's in New York at their conference, their guy that's his counterpart in New York, come to him and said their biggest issue with fraudulent tops is from Georgia. So it's a huge issue, and we've got to get a handle on that problem, and that's the genesis behind the study committee, where we can study it more and come back hopefully next session and do what we need to do to address the issue.
Number 26.
Yes, sir, Mr. Chairman. We're on that LC 393930.
And I will need to make an amendment on the effective date on there. Good catch.
Yes, sir.
Yes.
That's what I was going to ask. Thank you, Mr. Chairman.
Thank you. Yeah, And I would, we're on the line 60, would like, someone to offer amendment to change that to 2024 at the proper time, if it's the will of the committee.
Any other questions? Number 27.
Mr. Chairman, I appreciate your work on this, and I think it's probably the proper time to make the motion do
I
pass.
think it is the proper time.
Yeah, you don't need
All right. Do I hear a motion? We have a motion. We have a second. All right. Discussion, comments, amendments. As we had said on 60, change that to 24. All right. We have a motion in front of you. Any questions of the motion? All in favor say aye. Aye. Opposed? Now, going back to the body of the bill as a committee substitute.
Yes.
As a committee substitute, we have a motion, we have an amendment. All in favor say aye. Aye. Opposed? And the ayes clearly have it.
Thank you, Mr. Chair. Thank you, members of the committee.
I'm sorry, I gotta leave you, baby.
Oh. You missed that.
Well, this is for this upcoming one.
Okay, I thought that was on mine. Okay, I missed. Okay, we do have one other measure on for us this morning, and she waited patiently in the back on us, 1284. And I know some people have to slip out to rules early, which I might have to. Matt, I might have to get you to take over. I do have two bills I got to get presenting rules this morning, so.
Thank you, Mr. Chairman. I'll be quick. I know that many of y'all are trying to get to other places. This is the bill that was heard the other day. We've been referring to it as Addie's Law. I'm working from LC 394288S. So everything in the bill is the same as when I presented the other day, except on line 34. There was some question on whether or not DOR had the ability to collect contact information of the insurer. And so that was added to make sure that they had the authority to do so.
What line was that again on? I'm sorry.
34.
34. Have you heard from anybody with DOE or?
Yes, so
talk.
DOE is in favor of this bill. GA Gale is also in favor of the bill, and also heard from Gwinnett. What is his name? David Goldie. So he's also in favor, and they think that this is a pretty good measure to move forward. For the committee members that weren't here the other day, quick synopsis of the bill. We had a young lady that was killed trying to get on her school bus a couple weeks ago, and after looking nationwide at what some of the penalties are in other states, we determined that it would make more sense in Georgia to increase the fines currently associated with it, and also encourage our local school systems to plan their routes accordingly.
And that's whenever possible, when it
Yes.
makes sense, not.
Correct.
Okay. We have a couple questions. Number 16, Representative Kennedy.
Thank you, Mr. Chair. Thank you, Representative Daniel. Again, I agree with the spirit and the intent and have a lot of empathy for the family that lost their daughter. It's tragic. I do have a couple of issues with the way the penalties will be meted out, and wonder if you're amenable to some other ideas. In sections 46 through 54, when we're addressing the uniform traffic citation, I agree that it should be punished as a high and aggravated misdemeanor. I would like to see if we could interject some judicial discretion and maybe make a range up to 1,000, but keep a minimum of 250, but let the judge sort out the facts, find the context, and maybe eliminate the jail time. So in a uniform citation, $250 to 1,000, let the judge decide. And in section 55 through 60, I think with that camera violation, $1,000 is very difficult. I know that there's a lot of small businesses and even nonprofits like that have a fleet of company vehicles driven by volunteer drivers, but the penalty would come back on the owner or the organization. And I can tell you $1,000 per hit. We don't have a lot of this, but across 17 years, we've probably had 2 of these camera violations, and we paid the $250 as the organization. $1,000 would be debilitating.
Yeah, so let me address a couple things. So if we took away the jail time option, that would actually lower what's already in code, to my understanding, when I talked to Ledge Counsel, because judges already have. So depending on how many times this happens, the fine increases. So if we were to just set a standard of 250 and then the judge could decide, then it's also possible that we would, if they're charged 500 currently for a second violation, we would be taking that away. So we would actually be, I guess, not strengthening, but the opposite of what we're trying to do here. So, and I did look at other states. Like, this puts us on par with most states. Indiana has it as high as 10,000. And in terms of small businesses being affected, you also, in current code, you have the ability to go and make your case in court to where, if you weren't the driver, they would,
It's just difficult to do to navigate that. Plus, as a nonprofit, these volunteers, these drivers are volunteers. I wouldn't want them to have to pay it. We would pay it, and $1,000 is a lot of money for a nonprofit.
Right.
All right, we have several other questions. Number 8, Chairman Prince.
Thank you, Mr. Chairman. And going back to we're going to line 17 on in section 2. This is just something for school systems to consider, correct?
That is
not
correct.
Shall.
Yes.
Okay, because I know in Richmond County we have problems just finding bus drivers and getting kids to school on time. They're running different routes, and this right here is definitely
Yeah, so that was something that I discussed with numerous people, was trying to make sure that this was something that was feasible, because there are one-way streets. There are things that, there are areas where this just simply is not possible. And so this simply says that they must consider, where possible, that they make every effort, essentially.
All right, as long as it doesn't mandate.
Yeah.
All right.
Yes, sir.
Number 9, Representative Montahan.
Thank you, Mr. Chairman. And to my seatmate, thank you for this bill. I know y'all have had a absolutely heart-wrenching situation down in your neck of the woods. And as someone who operates a driver's education facility, I know firsthand, have seen how many of these folks disobey these laws and putting our children at risk. And so I appreciate your bill. The civil monetary penalty shall be $1,000. I think I'm on the flip side. Do you think that's enough for endangering our children?
So when I originally drafted this bill, I had it at 2,500, and so we lowered it to 1,000 for people to be a little more amiable.
Well, coming on the heels of such a tragedy, I understand your sentiment, and Mr. Chairman, at the proper time, I'd like to make the motion.
Thank you. Representative Whithour.
Thank you, Mr. Chairman. Just a few comments to Chairman Prince. Yeah, I had the same concern over the shall. It merely shall consider. I did clarify that as well with my local, because it would not be possible in my area whatsoever to avoid roads of that. To Representative Kennard's comments, respectfully, I appreciate where you're coming from, and certainly appreciate your work in the nonprofit world. I would suggest that if you have volunteers that are continuing to pass buses when they're stopped, you maybe shouldn't pay for their fines. This is a situation where obviously this is not the only tragedy. This may be the catalyst for this situation, but this is not the only time this has occurred. As far as the jail time, it's not more than 12 months, and as I read it, it is not less than $1,000 or. So I guess in a really extenuating circumstance, a judge may quite frankly, if I look at this, a judge may say you can spend a night in jail. And then you're not even paying $1,000 because it's a maximum or not less than 1,000 or by confinement not more than 12 months. So in a situation where there was we'll just say an impoverished person that's been charged with this crime or gotten this ticket, I can certainly see how a judge might decide their leniency is merely spending a night in jail. So I appreciate the measure, and I will gladly second Representative Montahan's motion when he makes it.
Thank you. All right, I see no more questions. Any more questions? At the proper time, I've already heard a motion and a second. Oh, I'm sorry. I apologize. I knew that. Yes, ma'am.
Thanks, sorry.
No.
Don't mean to be out of order.
No, I was out of order.
My name's Maisie Lynn Gerton. I'm the Executive Director at the Georgia Association of Criminal Defense Lawyers, and it is never my pleasure to have to oppose legislation on the heels of such a tragedy. I'm a mother of 2 young children who attend a public school just down the street. We don't have buses, so this is not something I have to manage in my own life every day, but I did certainly grow up riding buses, and so I realize that this is a serious matter that you're taking under consideration. But the penalties that are being laid out in this legislation are also quite serious. Representative Wiedauer, there are 2 mechanisms by which someone can be cited for this sort of violation. One is, as you've described, when you end up in the court system, you get into the courthouse 2 ways. One is if an officer observes that traffic infraction, and you know, it's a roadside citation that's issued to you by a police officer standing at the roadside because she witnessed the behavior. In that situation, the only mechanism that you can use to resolve this violation is to go to court. And when you go to court right now, as you all know, many of our moving violations are misdemeanor crimes. So you are facing up to $1,000 penalty and up to 12 months in jail, or both, as you've described. That person who gets a roadside ticket cannot avail themselves of the civil penalty that you all have laid out in this code section. The civil penalty is only available to those people who are cited by camera. So when the arm of the bus goes out, the camera comes on, the citation issues, there's a mechanism, you have a process that you've laid out in 46-163 by which the citation is then sent to the driver. This is where it becomes an issue of the civil penalty is meant to be assessed to the owner of the vehicle, could also be the driver. The roadside citation is certainly for the driver. When someone gets that civil penalty in the mail, they also can go to court and avail themselves of that adversarial process. But what they are doing then is opening the door to not only the monetary penalty, but also now jail. So the incentive, of course, is to leverage the civil penalty. In this current legislation, by increasing, the only way to get past that $1,000 threshold is to increase this to a misdemeanor of high and aggravated misdemeanor, which is what's happening in HB 1284. That allows you to access up to $5,000 worth of financial penalty. What it also does is if a judge does decide instead to issue a jail time sentence, it removes what we call good time credit. So on any other moving violation, you would be afforded what we call good time, which is where you spend 50% of the assessed jail time in custody. But on this one, when it's a high and aggravated misdemeanor, you do not. You have to spend day for day. By increasing this penalty 400%, you're not only increasing the penalty that the person would have to pay, you're increasing the profit to the companies that are enforcing these infractions for us. You know, I know this committee is very familiar with lots of different cameras for monitoring traffic violations. One of my colleagues recently, unfortunately, got a camera-issued ticket and the collection is going to run through an organization in Tennessee. And the money that gets remitted back to the locality here is only after the for-profit companies take their piece. So while I understand the spirit here, our hope is that you would consider something less punitive with respect to the fines, as Representative Kennard has potentially raised, whether that means lowering the floor back down to $250, where it can still go up from there to $1,000. And as we all know, judges can take the individual facts and circumstances into account in ways that no one else can. And when they are faced with someone who sincerely cannot pay the $1,000 up front, the other thing that kicks in is probation. We have probation set up so that people can pay fines, but then not only are they paying that fine, but they're also paying a probation fee on top of that. The collateral consequences of raising this fine, quadrupling this fine, are exponentially higher than that for the person who's economically disadvantaged and gets caught up in this sort of a traffic violation. I would also turn your attention to the fact that when you look at the NHTSA study, the most recent NHTSA study I could find runs from 2004 to 2013. And of those fatalities that occurred, unfortunately, eight of the 100, about 10% of them were by the school bus itself. There certainly seemed to be some need for education here in lots of different ways. But we would ask you to respectfully consider not quadrupling this fine as the mechanism today for trying to deter this behavior. I would stand for any questions that you have.
All right. Representative Alexandra?
Thank you, Mr. Chairman. I know you mentioned about the number as it relates to the fatalities. Do you know what the current system number as it relates to people passing a school bus?
I did not find those numbers, no. I think that would be something we'd have to get depending on how the citations are issued. In Georgia, unfortunately, we don't have a central repository for much of our criminal legal system data. And so if it's a local ordinance that's being enforced, you'd have to go to the localities and then go out and add them together from there. If it's, no, I don't have those numbers, and I'm not aware of any collection of those numbers, though there could be.
Right. Thank you for your data.
Thank you. Are there any more questions for the speaker?
Thank you.
Thank you, ma'am. All right.
Mr.
Representative Kennard?
I would like to offer an amendment when it's appropriate.
Can I respond? Is that okay?
Yes, ma'am.
All right, so I actually have some numbers from the National School Bus Loading and Unloading Survey that is, so they've compiled this pretty substantially, and I want to make sure that we're all aware that children from the ages of 5 to 9 are the most commonly hit. And there have been several, I would say, 5 years old, 170, 6 years old, 278, 175, 8, 137, and 9 years old, 97. So those are children that have lost their lives. And it is further broken down by whether or not they were getting on the school bus or if they were crossing the road, and the majority of them are when they are crossing the road. I understand why the criminal defense attorneys would be hesitant, but the things that you heard her mention, I actually did intentionally. This was not something that was flippantly done. Working with Ledge Counsel, the high and aggravated misdemeanor puts it on par with reckless driving. And other states actually have it more severely than this. They put it on par with DUI. And so when I wrote this bill, I wanted to make sure that what we did was not going to ruin someone's life. I didn't want them to immediately go to jail, because some states do. They put them in jail for 90 days on the first offense. And so all of this was taken into consideration when this piece of legislation was drafted. And so I want the committee to be well aware that this has been thoroughly thought through. And I'll answer any questions you may have.
I see no questions. Whoop. Take it back.
Chairman, if that is really your intent, then why raise the fee?
So with the fee, so the last time I was here, I talked about how often people pass school buses. In 2019, nationwide, in one day, 95,319 people crossed a school bus while their arm was out. And every single time somebody makes the choice to pass a school bus, you run the risk of hitting a child. And so we are dealing with something that every time it is done could cost a child their life. I don't think that this is something that you can put a monetary value on in any capacity. And so I think that this is actually a middle ground.
Thank you. Representative Kennard, you had a motion for an amendment, but might be others. Oh, I'm sorry. Thank you. Oh. Who's that? Oh, is that Greg?
A motion and a second.
Yeah. We have a motion and a second. All those in favor? Okay. I'm jumping, sorry. Any discussion? All right. Thank you. I'm sorry.
I would like to make a motion to offer an amendment, please.
Okay.
And maybe Jenna can help me with the language here, but the intent for me would be to, on the uniform citation, to have a range of $250 to $1,000. Is there an option to keep it as high and aggravated?
Yeah.
Let's keep it as high and aggravated, but just the range of penalty, $250 to $1,000.
Line 53 would be a fine of not less than $250 nor more than $1,000.
Yes. And let's keep the confinement in there as an option. Second part of that amendment would be sections 55 through 60, just to go back to the original language on the civil penalty of $250.
Second.
Jenna, would this put this in on par with what's currently in code if we were to make those amendments?
So currently it's a misdemeanor, not a high and aggravated.
Right.
Which is up to.
But I'm talking about the fines themselves. Because currently it's at $250, correct? And then
Right,
it can
yeah, so
be
we would just take
it can be
that
up
out.
to $1,000 currently already.
So 55 through 60, if we're going to keep it at 250, just take that out of the bill because it's no longer being amended. I'm not sure if that's what your question is. It's currently 250 for the camera.
Right. Okay.
Just 1 minute. We have a motion on the amendment. Is there a second? And we have a motion and a second. All those in favor? Right. All right. All those opposed? I'm sorry. I'm off today. All right, the amendment passed. And now a motion on the whole bill as substituted, right? All those in favor? All those against? Passed. Thank you. As amended, yeah. And I believe that was our last bill. Thank you very much.